Morning. The 13th District Court in the state of Michigan is now in session with the Honorable Judge John Coleman presiding. While court is in session, there will be no eating, sleeping, talking, dumb, chewing.
All right, this is case number 2416-9257. This is LBME Funding versus Walter Fortner, Fortsum, I'm sorry. The matter is before the court, set on for a hearing on today's date, but should reflect neither party appeared at a previous hearing date. All right, for LBME Funding, please. For LBME Funding. All right, do I have Walter Fortsum here? And I will pass and recall those matters, that matter at a later point. This is case number 24-152-651, Rodnick Chiropractic versus Farm Bureau Mutual Insurance. Do I have counsel for Rodnick on this Zoom at this time?
Yes, I apologize, Your Honor. He is on another hearing. He will be here shortly. He has, I believe, 4 matters with you this morning.
Right, thank you, counsel. Do I have counsel for Farm Bureau?
Yes, Your Honor. Reed Powers on behalf of Defendant Farm Bureau.
All right, thank you, Mr. Powers. I'm standing by with yours as Mr. Fortner is in another courtroom, and I'll come right back to it as he comes in.
Thank you.
Counsel. The court also is calling Rodnick Chiropractic versus State Farm Auto Insurance 24-17045. Do I have counsel for State Farm?
Yes, Your Honor. Genevieve Lee for Defendant State Farm.
All right, I want you to know, Ms. Lee, that I know that you're there, and I'm putting yours just behind or after the one I just called, and we'll get right to you when Mr. Porter comes in.
Understood. Thank you, Judge.
Thank you, counsel. I'm calling now Northland Radiology Incorporated versus Smart, case number 24-172-658. Do I have counsel for Smart?
Yes, Your Honor. Mohammed Sheikh for Smart.
All right, thank you, Mr. Sheikh. I wanted you to know that I know that you are there, and I am setting that matter over for when Mr. Fortner comes in with work of his cases.
Thank you.
Oh, I'm here, Your I'm here, Your Honor. Good morning.
All right, good morning to you,
Thank
Mr.
you for
Fortner.
waiting for me, Your Honor.
Thank you, sir. Your appearance with regard to the suffix 2658, that's Northland Radiology Incorporated versus Smart. I'm on the record in that one at this time.
Yes, Your Honor. Michael Fortner, P46541 on behalf of plaintiff.
All right, thank you, Mr. Fortner, and thank you, Mr. Sheikh, as you ended your appearance previously in this matter. All right, somebody want to update me regarding where things are with this matter?
Yes, Your Honor. I believe this is the first pretrial conference in this matter, and so defendant would request that open discovery.
All right, anything, Mr. Fortner, at this time?
Nothing, Your Honor.
All right, the court will set the matter up on a 60-day calendar, and I will set the return date, the return date of this matter as the 22nd of May 22nd. You will get a scheduling order in the mail from me with that date, May 22nd at 9:30. Discovery will be open through that date, and that will be contained in the order as well. So I'll see you on the next action date. You'll get my order in the mail in the next few days.
All right, thank you very much, Your Honor.
Thank you, Your Honor.
Mr. Fortner, stay right where you are. I'm now on the record in the suffix 0445. That's Rodnick Chiropractic versus State Farm Mutual Auto Insurance Company. The matter is before the court, set for a pretrial hearing. I think I have it set for a final pretrial conference. And your appearance regarding that matter, Mr. on Rodnick Chiropractic, please.
Thank you, Your Honor. Good morning. Michael Fortner is here on behalf of plaintiff P46541.
All right, thank you, counsel. And I have State Farm and you previously ended your appearance. Where are you now?
Yes, Your Honor. Go ahead.
No, you go ahead, counsel. I'm sorry.
Thank you.
The parties stipulated to opening discovery about a month ago. We would just request a brief adjournment, and then I would actually also request an itemized demand from Mr. Fortner, and then we can move this case along.
All right. Okay, I didn't hear a part of what you said. I know that you're requesting a brief adjournment. I will certainly grant the same. We'll come back. You said something else, and I want to make sure I heard you.
Yes, Your Honor, just that the parties have already stipulated to opening discovery, and that I'm requesting an itemized demand from Mr. Fortner.
All right, thank you. I did receive the stipulation for discovery, and I did sign the same on 2/20/25. I don't know that I issued a scheduling order in this matter. So I'm going to formally issue a scheduling order and bring this matter back on the 22nd of May at 9:45 a.m. Mr. Porter, anything you wanted to add in this regard, sir?
Nothing, Your Honor. Thank you very much.
All right. Thank you. And you heard counsel, I think she said she wanted an itemized, some itemization from the counsel. Are you prepared to present that, sir?
Yes, Your Honor. We can get the bill over to the counsel.
All right. All right. Thank you. Thank you, counsel. All right. Good day to the two of you. I'll see you on the 22nd at 9:45.
Thank you, Your Honor. Have a good day.
And good day to you. And I'm on the record now regarding Rodney Chiropractic versus Farm Bureau Insurance. That's the suffix 2651. And Mr. Fortner has indicated his appearance on behalf of Rodney, and that appearance is continuing in this matter. And I received the appearance of counsel regarding Bureau Mutual Insurance at an earlier time. All right, let's proceed then. It looks like I had this set for final pretrial conference. Somebody tell me where things are, if you will.
Yes, good morning. Good morning, Honor. Reed Powers, again, on behalf of Defendant Farm Bureau. This is our final pretrial. I would request an adjournment, if possible, as there are 4 other provider suits involved in this matter. 4 other provider suits, along with an additional individual suit by the claimant. The claimant has bills that total over $250,000 for the cap in this case. So we are trying to set up a global facilitation to get all counsel involved from all provider suits and the claimant's individual suit. So I would request an adjournment of this final pretrial to allow that facilitation. But if we do need to get a trial date on the books, then I would request at least 60 days time for us to get that facilitation done.
Mr. Porter?
Yeah, I think we can get a facilitation done, but I don't want 60 days. I think 45 days to keep the pressure on us. My experience has been that the pressure of a trial date is what moves these things along, quite frankly. And the longer it stays out, the longer it takes to get things resolved. So if you give us a trial date in the next 45 days, I anticipate that we will at least have the facilitation done and be much closer to settlement than we are now.
Your Honor, if it's all the same, I would appreciate 60 days just so we can ensure that we get facilitation done. We do have a lot of other counsel we're communicating with. We've already got the ball rolling on scheduling facilitation. So I just want to have as much time as possible to make sure that we get that done, not butt up against trial.
Yeah.
Let me respond to that for a minute, Your Honor. Just for a second. Because, and I don't know this young lawyer, but see, the whole concept is disingenuous because they know they got a $250,000 cap. They know that the claims exceed $250,000. They know what they have to do. They have to file a 3112 motion and ask for an apportionment if they really want to get this thing done. And so, they're just all they're doing is running up their meter and running up their attorney's fees, but they waste our time. And it makes these cases go to trial when the reality of the situation is they should have been resolved a year ago. So that being said and done, the less time, the better. If we're gonna get the thing done, let's get it done. If we're not gonna get it done, let's try the case.
All right. I guess the concern that I have, obviously, I don't like delays, but when you're dealing with a situation where obviously you got a cap situation involved, and apparently there are multiple lawsuits and multiple attorneys involved, it does make sense that if we're talking about the difference between a difference of 15 days I'm probably going to err on the side of allowing that additional time, given that you have a significant number of attorneys that are involved in that. So I'm going to, I'll go ahead and I will set a trial date in this matter. I'm going to set that date for the 20th of May, May 20th, at 10:30 a.m. May 20th, 10:30 a.m. Matter set on for trial.
I'm sorry, Your Honor, did you say the 28th or the 20th?
May 20th. 20th.
20.
Thank
Okay.
you.
Thank you.
Yeah. That should give
All right, thank
adequate
you, Your Honor.
direction. All right. I wish you well, and I'll see you the next action.
All right, thank you very much, Your Honor. Your Honor, does that,
I think you have one more. Just
Okay.
hold on.
all right.
The court now calls case number 24-171896. This is the one of Woods versus Smart. The matter is before the court, settled for a general hearing. I believe that this is the first hearing date regarding this matter. I have it set as a status conference. Your appearance for the one of Woods, please.
Thank you, Your Honor. Michael Ford is here on behalf of plaintiff P46541.
Thank you, Counsel. For Smart, if you will.
Good morning, Your Honor. Mohammed Sheikh, P82819, appearing for Smart.
All right, thank you, Mr. Sheikh. Good morning to you again. All right, so I know that this is the first hearing. My inclination is to set it over, giving discovery and allowing other opportunities pursuant to my scheduling order. Should I do anything different? Any information that needs to be brought to my attention at this time?
Your Honor, I would only request that if the court would allow discovery for at least 90 days in this matter, we would appreciate it. This is a patient's suit. This individual was a passenger on a bus, so this case might require just a little bit more discovery than 60 days. So if the court would allow that, I would appreciate it.
Mr. Porter? Anything, Mr. Porter?
Your Honor, well, it's your discretion. I don't mind if the court does so allow.
All right, thank you, Mr. Sheikh. I will go ahead and send it over. That's going to put it in Madam Clerk. I'm looking to see June right now.
June, which date?
You
want like first of June?
No. I'm looking at June 19th. That'll give us 90 days out. June 19th, that will be the return date. June 19th on the at 9:30. 6/19, 9:30.
Thank you, Your Honor.
With a scheduling order for me in the next few days.
Thank you, Your Honor.
Thank you. Good day to both.
You as well. Thank you.
Ooh, Judge, the entire day is blocked.
All right, Mr. Porter, are you still there? Do I have Mr. Sheikh? Mr. Sheikh, are you yet there?
No.
Madam Officer?
Judge, I will go ahead and I'll give them a new date.
Yeah, that's enough time. Just change the date. Okay?
Yeah.
All right.
I'll do it on 17th, is that cool?
Yeah, okay, I'll be right with you.
Okay. June 17th,
Thank you.
Judge.
They wanted 60 days, so good. Just passed.
Oh, just passed, I'll give that Monday.
Okay, sorry, that's fine. Thank you for catching that adjustment. All right, the court now calls case number 24-1034. This is Melody Brooks versus Tanisha Cobb. The matter is before the court on the issuance of a subpoena. The court previously issued that subpoena for hearing on the 26th, but granted an adjournment until today's date on the subpoena. Do I have Melanie Brooks on the Zoom? Say something if you're here.
I'm here.
All right, thank you, Ms. Brooks, and good morning to you. I'm
Good morning.
looking for Ms. Cobbs or Tanisha Cobb. Ms. Cobb, if you're on this Zoom, please say something. I do see something indicating Tanisha. Please say something if you hear Ms. Cobb.
Tanisha Cobb, I'm here.
All right, thank you very much, ma'am. This matter is before the court regarding a judgment that was entered and the plaintiff's effort to collect on that judgment. The judgment was entered for $4,330.49. That judgment was entered on the 1st of October of 2024. And so Ms. Brooks has asked the court, or obviously, thanks for this. All right, she has asked the court to issue a subpoena so that she can acquire information. Let me ask you, Ms. Brooks, have you received the information that you are requiring?
I don't have any information. She said, when we spoke in the breakout room, she said she's prepared to make payments, but
All right.
I don't have any information or nothing.
All right, very well. All right, so Ms. Cobb, today you would have to give information under oath, but we got to set up a way for these payments to begin. So tell me what you're proposing to do at this time now.
I can do monthly payments. Right now I'm in between jobs, but I can commit to doing monthly payments if granted.
All right, so how much are you proposing to pay regarding this matter?
As for right now, I can try to do at least like $100 a month for now.
Oh my goodness.
All right, Ms. Brooks.
I'm here.
All right, what do you have to say about that? Here's what my thought is, Ms. Brooks. Ms. Cobb is saying that she is not working at this time. I would set I know the judgment is a pretty substantial amount, and $100 is not a lot going towards that. What I would do is I would allow her to make those payments, and I will set a date 90 days hence to review if she's making the payments. And then at that time, it'd also be reviewed as to whether or not the payment should be increased, because at $100 a month is going to take it's going to take 4 years to pay this, and that's not about 4 years. That's not fair. So I can't leave it at 100. We can start there. What do you think about that, Ms. Brooks?
Yes, sir. That'll do for now. We can start at 90 days for 100 and review it then.
All right. So Ms. Cobb, that makes sense to you, ma'am?
It does.
All right. So what I'm going to do is I'm going to sign an order. That order is going to say that $100 is paid per month. I'm going to make that first payment due on the 4th of April. So you'll have to get in contact with Ms. Brooks so you know how to make that payment by Cash App or somehow. It's got to be paid.
I would rather her do money orders. That way she got proof that she paid me what she's going to give me, and I got proof of what she gave me.
Well, you all figure that out. You all figure that part out. If she doesn't want to do money order, she can figure out other ways in regards to keeping a record. So whatever you do, if you do Cash App, that establishes the record. If you do Zelle, that establishes the record. So the two of you figure that part out. One way or the other, you have to get the part by the 4th of April. Otherwise, you're in violation of the order. And then each month thereafter, you have to make the payment by the 4th. If the 4th falls on a Sunday, then you would pay it on that Monday the 5th. All right. And then so I'm going to set a hearing date in June. And that hearing date in June is going to be June the 9th. June the 9th at 9:30, I'm going to review the schedule of payments, and I'm going to make decisions regarding whether or not the amount should increase. So you'll get a notice from me for a hearing on June the 9th at 9:30 a.m. In the meantime, the order provides for a $100 payment to be made to Ms. Brooks by the 4th of April and by the 4th of each month thereafter until further order. Right. I wish both parties well, and good day to you.
Thank you. Have a good day.
Under those circumstances, the subpoena is adjourned. So the subpoena is not resolved, it's adjourned. If the payments are made, then it'll work itself out. If not, then what will happen is that the defendant will have to answer under the subpoena, provide information, social security numbers, and so on and so forth. But we'll cross that out. All right, good day to both of you.
Thank you.
Tanisha, I got your number. I'll call you.
Okay, call me.
Oh, you got a new number.
Yeah, no, it's a new number. It's a new phone.
I don't know what I said. Here, just take my number down. And
I'll do that. I'll do that because everybody have your number. Let me put you guys in.
Okay. Could you put us in a breakout room?
Put you in a breakout room real quick, and y'all go ahead and work that out.
Okay.
There you are. All right. All the best to you.
Okay. Thank you. Tanisha, can you hear? Oh, Joanne.
I need to do an order on that. All right. This is case number 06-13291. This is Focus Hope versus Joyce Bivens. The matter is before the court on an objection to a writ of garnishment. The record should reflect that in this case, a judgment was entered in 2006, and that judgment due I should say the judgment was entered in 2007. It was renewed subsequent to that time. Judgment of entry was for $4,303.82. This is an effort to collect on that judgment. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Timothy Tremberth on behalf of the plaintiff, P79117.
All right, thank you, counsel. And I'm also looking for Ms. Bivens, if you're on this Zoom, say something at this time.
Yes, good morning, Your Honor.
All right, good morning to you, Ms. Bivens. And I do see that there are two objections to the writ of garnishment. One, in relation to the Michigan Department of Treasury. The other is in relationship to, it looks like Giant Janitorial. All right, in reviewing the objection to the writ of garnishment in regard to the Treasury, it says, object to the written statement I received from the creditor because the balance of the judgment is wrong. The other objection I received regarding Giant does not have anything specified. Tell me, ma'am, what's the basis of your objections at this time?
Your Honor, I love my son very dearly. My son was an adult when he entered into that school. It was a free program, as far as I know about Focus Hope. I don't know anything about me being charged for my son's attending school. When the attorney sent the letter to my part-time job, which is Giant, they referred the letter to me, and they had it in my name as if I went to school. I did not attend Focus Hope. My son Tyrone Bivens attended Focus Hope. And my treasury that I'm trying to get my federal funding is, I'm on a fixed income, I'm on SSI, and my adopted children was foster care kids. Those are their funds. I don't have much funds. And this is my son's bill. It's not mine. They did not even indicate my son's name on it when they sent it to my job, which is Giant.
All right, thank you, ma'am. Well, the issues that you're raising at this point are pre-judgment issues. Those are issues before the judgment was entered. There was a lawsuit filed against you back in 2006. You didn't answer the lawsuit, and that's how the judgment got entered. That judgment has been in place for a substantial period of time. So you can't really raise those objections today. That judgment is not only against Tyrone Bivens, that judgment is against Joyce Bivens. And that judgment, again, is from back in 2006. This judgment's been around for a long time.
Yes, it has. And I've been going to court about this that this is my son's bill and they had been taking his taxes when he was working. So I'm not clear on how it's got to do with me.
Yeah, well, the judgment is against you. It's against you. And when you understand that part of it, then I understand some of the arguments you're raising, but the issue is that you have a judgment against you. This is way beyond the school. You have a judgment, and that judgment is 14 years old now. Let me hear from the other side, counsel.
Your Honor, I would just say we rely primarily on our response, given that I think you hopefully received it. And as you stated, the defendant's objections are based on attacking the judgment, and an objection to garnishment is not the proper way to attack those, and it's not appropriate to attack that in a objection to garnishment.
Yeah, and that's a number one part of the challenge here, is that there is not a valid objection that's being raised at this time. To the extent that Ms. Bivens, that you feel that the judgment should be set aside, you have the right to file a motion to try and get that set aside. But as I pointed out to you, it's already been 14 years, but you can't attack it in a post-judgment hearing. The only kinds of things that you can attack in a post-judgment hearing like this is things like the judgment has already been paid. I've already set up a payment plan, things like that. None of those issues have been raised, and so there's not a valid objection. First of all, as it relates to the Michigan Department of Treasury, and there's certainly not a valid objection as it relates to giant janitorial in this matter. Now, you pointed out that you receive benefits by way of the federal government. Certainly, those benefits cannot be garnished. In other words, if you receive any type of disability or anything like that, if someone tried to garnish your bank account or something like that, they can't do that because federal funds are exempt from garnishment. But certainly, if you're working, they can garnish your wages at work, even if it's part-time. And if you file a Michigan Department of Treasury tax return, they can garnish the tax return. Yeah, they can't garnish anything federally. They can't garnish a federal tax return. They can't garnish federal disability payments. None of that is stuff that can be garnished. They can garnish the Department of Treasury tax return, and they can also garnish any place that you might be working. And that's the nature of these two garnishments. I don't find a valid objection. The issues that you raise, you can raise those in the context of a hearing where you're seeking to try and get the judgment set aside if you wanted to do that. Again, I already pointed out that this judgment is 14 years old. I know that you pointed out to me very clearly that it was your son that went to school. I don't know how they got a judgment against you, but apparently you signed off for him to go and there was cost involved. I don't know if that's true or not. I know that you have judgment.
No, I never did sign off on anything.
No, and don't care. Don't know and don't care. And I'm not being insensitive to you, but I need you
I understand.
that you got a judgment. That's the part you need to hear, because it's that judgment that's causing you problems. That judgment can interfere with your wages anywhere you work. It can interfere with bank accounts. And again, like I said, if you got money in there that's from some type of federal benefit or something along those lines, they could hold the account up and they can't garnish it once you establish that it comes from the government. Anything else, they pretty much can come after you because this judgment is against you. And I need you to understand that part. And you can decide what to do next, but as far as attacking garnishment, you don't have a basis for that because there's a judgment. All right, that's my determination. You'll get 2 orders from me in the next couple of days. I do wish both sides are well regarding this regarding these matters. So, good day to you.
Thank you
All
very
right,
much.
thank you, Your Honor.
All right, this is case number 10-5669. This is Aaron Financial Services LLC versus David Williams. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this case on the 10th of August 2010. That judgment was renewed subsequent to that time. Looked like that renewal was 7/20/20. And the judgment balance at the time was $1,986.46. All right, your appearance for the plaintiff in this matter. For Aaron Financial. Do I have David Williams?
Yes, sir.
All right, thank you, Mr. Williams, and good morning to you. I know that you have filed with the court objections to a writ of garnishment. I also know, all right, counsel, are you here on Aaron Financial?
Yes, good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Okay, all right. Somehow I called for you earlier and didn't get a response. But thank you, counsel. I see the objections to the writ of garnishment. I also see a motion to set aside a default judgment in this matter. All right. So let me first address the motion to set aside the default judgment. It says that 21 days have passed, but I've not been personally served, and I have good cause for setting aside the default in this matter. I'm looking at the file, and just one moment here. Contained in the court's file from 2010 is an affidavit of service by posting as allowed by the court at the address on Penrod to Mr. David Williams. Personal service was not required because the court allowed service by posting. All right, so the issue of personal service is not an issue in this case. Moreover, it's been 15 years, and this is the first instance of a motion to set aside a default. So what are you talking about, Mr. Williams?
This is my first time ever hearing about it. When I got the written garnishment by my employer, I never knew. I wasn't even in Michigan at the time when they were saying they was trying to serve me. I stay in Florida, sir.
Yeah, well, the judge at that time, many years ago, allowed the service by posting. So that is good substitute service.
But how can I? I'm sorry, sir, but how can I dispute something that I didn't even never know about?
I don't know, but no, ma'am, you can't say anything at this point. Over several years, there were several notifications of garnishments against income tax involving your Social Security number over several years, back in 2010, 11, 12, so on and so forth. And so 15 years later is when you come forward and say that you never heard anything about this. And of course, the information that you provided, even as it relates to your objection, that certainly does not have a Florida address. So I don't think I see a basis for setting the judgment aside. I'll address the other issues in a moment. Let me hear from Mr. Johnson on this, sir.
Yes, Your Honor, thank you. Based on the defendant's motion, he was under the impression that we had the Southfield address for 15 years, and it's just not true. It was served appropriately back in 2010, and we've renewed the judgment. We are way past any type of reasonable time to talk about setting aside a judgment that has been renewed.
Yeah, I just don't see a basis that would allow me, although, I'd look for that. I don't see a basis that would allow me to set this judgment aside. There's just no basis to set it aside at this point. So that motion in that regard will be denied at this time. Just, there's no, I have to have a legal reason, and I have no legal reason for setting this aside. So I can't set the judgment aside. Now we deal with the objection to the writ of garnishment. The objection to the writ of garnishment says, I never received notification until 15 years later. I never had a chance. My address is not, that's not my address. I believe the information is fraudulent. That, you can't even raise that in the context of an objection to a writ of garnishment under the court rule. So you don't have a valid objection to the writ of garnishment. Legally or factually, do you have a basis for setting aside the garnishment? So let me ask you, sir. It looks like you work for OWI or CWI Logistics. Is that correct, sir?
That's correct, sir.
So has any money been taken from you regarding this case?
Yes.
I mean, all right. So how much? So do you get paid weekly, monthly, or twice a month?
I get paid weekly.
All right.
I'm sorry, go ahead.
I'm trying to find out how much has been taken from you in terms of weekly under this garnishment.
It's $168 a month. A week coming out of my check.
All right.
And I'm not even getting 40 hours.
Got it. So that's hitting you for this one more 4, 5, 6, about $700 a month, right?
Yes, sir.
All right. This
And may I say
judgment.
something? Okay.
Yeah,
Yes.
just a moment. Yeah, this judgment started out as $1,800 back in 2010. Counsel, what are you showing as a balance on this judgment this time?
Your Honor, I'm showing a balance on the judgment today, $5,530.61.
Have you received any payments on the judgment, sir?
Yes, Your Honor, we received a check. Well, we received it March 11th in the amount of $125.60. And then, hold on. Then March 18th, we received an additional check in the amount of $145.52.
All right, so any other payments that you're noting over the years, sir?
No, Your Honor, as the court can see from the record, there've been like 30 a lot of garnishments issued, unfortunately. And this does happen. This is the first one that actually hit where it was successful.
All right, sir. So I know I'm on the record here. Have the parties talked at all in a breakout room to see if you could reach some kind of way of resolving this? Because what happens is that the judgment been in place 15 years. You've got interest accruing on that, and it started out at like $1,800 or $1,900. The defendant is saying one of the issues here is that he did not receive notice. Legally, and there's a difference between legal notice and actual notice. Legally, I find that there's notice, but he's saying that he didn't receive notice. So it probably, here are two things I'll say for you. It's probably worth talking to see if you can come up with a number that resolves the case, something less than where it is now. The other thing, just listen to me. You can do whatever you want to do. I want everybody to understand that except for when it comes to the law and what I have to do, I'm gonna do what I have to do. You can do whatever you want to do. I'm gonna do what my responsibility is to execute the law. Sometimes I can give people some direction as to how you might be able to resolve it. You don't have to listen to me when it comes to that. I issue orders, but I know right now that what you're dealing with is a garnishment that's going to hit you for $700 a month. I can tell you that I will likely grant something less than that amount so that you're not able to garnishment that high. But maybe you can find a way that both parties talking to see if you can get away from that $5,500 that this has blown to. Okay, that's the only reason I'm talking about this. Listen to me now.
I'm sorry.
That's the only reason I'm talking about this now, to try to see if there's a way to help you going forward with this. That's all I'm trying to do. You may disagree with my rulings on the other stuff. You can always appeal me. You can always file something else. But hear me on this part of it, okay? This part of it is if nothing changes here today, that garnishment is gonna stay in place and you're gonna get hit for $700 a month. I will reduce that.
Can I speak for a second?
Do you understand everything I'm telling you?
Yes, sir, I do.
If you speak and you tell me something that's crazy, then I'm gonna be stuck with what you're telling. Go ahead, I'm listening.
No, sir, I'm not gonna tell you anything crazy. Right now, like I said, I'm not even getting 40 hours a week. I'm the primary breadwinner in my house right now because my wife is battling cancer. And that is gonna really, really put me in a bad situation. I have a child. I'm not telling you anything crazy. I understand that, what your judgment is, but I was just asking is there any way possible that could be, reduced or something, because that's going to really put me in a bind.
Absolutely.
Especially after 15 years when I could have been paid this. He's talking about there's been failed garnishments, but this could have been resolved. I didn't know anything about it. This is my first time ever even knowing about it.
He wasn't even in Florida. That's not your address.
And the other address that he has, that what they said that was the whatever was sent to. I've never stayed at that address in my life. I've never even known about the address.
You've been in Florida since 2009.
So if you want me to, I'll go hear other cases and come back, because you're telling me the same things that you already told me before. And that's okay. If you want to talk about that, that's okay. See, I told you, and the first thing that you started out saying, it makes sense to me. I'm not going to leave you under that $700 and something a month garnishment, because you told me earlier that you're working part-time. Then you added information that you're the sole breadwinner, that your wife has suffered with physical ailment, so on. So I take all that into consideration, okay? Two things that are relevant here. Now, I could just leave that in place, but I don't want to do that because I know that this has been going on for a long time, so on and so forth. The other thing that I know is that most of the judgment now is interest. So that's why I said talk aside. Maybe you can come up with some agreement where you get some of that interest knocked off of there. We have a lower amount. That might be worth talking about. Okay, I can address today just the garnishment. You talk to the other side, maybe both of you could talk about what to do about some of that interest that has accrued. Like I said, this started out as about a $2,000 judgment. It's $5,500. You had $3,500 in interest. So you may want to try to address that part. Then the final thing that I'll point out to you is that you can still file motions to try to get the judgment set aside from 15 years ago. The problem is it's 15 years ago. The problem is the thing that I described to you about what the files show. The files show legal service. The files show a alternate service that was allowed by a judge, not by me, but many, many years ago. And that established the way that this case would go forward. And that kind of ties my hands, okay? So that's the reason that you have the rulings that I made on the other issues. Now, I don't particularly like it, but that's the way that is. Now the challenge is going forward. So my sense about this is based upon what you have communicated to me, that I would cap your payments at $200 a month, so it'd be $50 a week, and that would cap the payment. But what you want to try to do is figure out a way if you can reduce the overall balance based upon how long this has been. And so instead of taking $700 a month, it would be taking $200. You'd be going towards paying it. If you could discuss trying to get some of that interest taken off, then that's going to lead to you getting it paid off back. That's what I'm getting at. And again, if you see a way to try to get the judgment set aside, if I knew a way, I really couldn't tell you because I can't give you legal advice. But if you find a way to get it set aside, I can't think of a way. But if you find a way, then I'll still be willing to hear that. But I just today, based on everything I see, there's nothing I can do about that part. Okay. So let me do it this way. I've already told you that I'll reduce that payment to $200 a month, $50 a week. Let me let you talk with the other side and see if you can do anything about the interest on this. And if you do something about the interest, maybe you can figure out a more aggressive payment plan and that'll reduce the amount. I don't know, but talk with him for a moment and then come back in. I'm going to sign the order reducing your garnishment amount. But again, if you can get the others reduced, then that'll put you that much further ahead. You understand?
Yes, sir, I understand.
Okay, so let's try to do that part. And I'm sending you in with Mr. Johnson, and then come back in. Let's see if we can work on it further. Because again, I know it's been 15 years, and I know that most of that is interest. All right. All right.
Yes,
so click on into the breakout room, and then we'll talk on the other side.
Yes, sir.
Okay, this is case number 12-105299. This is Asset Acceptance LLC versus Mariah Corley. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding a judgment that was entered in this case in 2012. The judgment was renewed in 2022. And in 2022, it was indicated that the amount owed was $3,690.09. The judgment previously was $6,390. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. David R. Monroe, P18081, Appearance Counsel for Asset Acceptance.
Thank you, Counsel. Good morning to you, sir. I'm looking for Mariah Corley.
I'm here.
All right. Thank you, Ms. Corley, and good morning to you, ma'am. I did look at your objections to the writ of garnishment. You said I'm not who they are trying to say I am. I wasn't old enough. So tell me what you're talking about there. It looks like this was somebody's paid on this judgment before. What's going on? What are you telling me, ma'am?
From my understanding, I have received a letter in the mail about, them garnishing my taxes. So, when I had contact, the parties about the matter, they told me that a bank account was opened in 2006. March 20th, 2006, and I told them that I was 14 at the time. And the name that they had sent the letter in, I was adopted when I was a kid. So my birth name was Jessica Wright. And my name now is Mariah Corley. So I had to take my foster parents' last name. But the name that they're talking about, that's no longer my name. And I was 14 at the time when the account got opened. So I don't know anything about it.
All right, so counsel, I am seeing the judgment entered as Jessica Wright. And then I see it, a subsequent indication of it formerly known as that then includes the name of Mariah Corley. And Ms. Corley says, of course, that she was a minor at the time that any of this occurred. Counsel, go ahead and talk to me.
I'm told by Asset Acceptance, Your Honor, that they have accepted her claim, her proof of fraud, and they are in the process of moving to vacate the matter in the case of the current garnished defendant. I would suggest you give us a month or so to get all that done, and hopefully it'll go away.
Your Honor, can I say something?
Sure.
They said give them a month or so, but the people that I had contact, they told me they was gonna send me something in the mail, and that was over a month ago. So that's why I decided to come down to the court to get a court date. They haven't sent me anything in the mail for me to even send to the IRS. I have 2 kids, and I'm a single mom. And the fact of them taking my income tax, I do not appreciate it. And they haven't did anything that they said they were going to do. Give you a month or so when I gave you over a month already. Like, it's not helping me out. I have bills, I have kids, it's not helping me out. Keep waiting. When I told y'all that wasn't me from Jump Street.
Finished?
Yes.
Okay. So you agree with them that this should be set aside, right?
Yeah.
Okay, that's what I thought. I know I'm glad you got that off your chest.
I just want my money.
I'm glad you got that off your chest. Want your money, there's a process involved. I'm glad you got that off your chest. All right, I agree that based upon what has been indicated here, that the objection is a valid objection. There is some paperwork that they got to do, but as far as before the court, counsel as an officer of the court has indicated that based upon the due diligence of asset acceptance, they've determined that your objection is a valid objection. Therefore, the court will find that the objection is in fact valid. When you told me that you were underage, that becomes a huge issue here. And if they hadn't looked into that, then I was going to have you present information, because if you could prove that you were a minor at the time, that would resolve it by itself. But they've already said that they agree with you that there was some fraud involved here. So I find that the objection is valid. Any funds withheld will be released to the defendant, that is to Ms. Mariah Porter. All right. I wish you well, ma'am. Thank you, counsel. And whatever process the agency goes through, they can still do that. But as far as the objection, I have to find that the objection is valid at this time. So, okay.
Your Honor, I assume you will file a written order to that effect and send it to them?
Yes, I'm signing the order now. This copy of this order will go to Ms. Corley. It will also go to the Michigan Department of Treasury.
Thank you so much, Judge.
All right, thank you, Ms. Corley. I'm glad you got it off your chest. Go take care of it.
Good day, Your Honor. Thank you, sir.
Good day to you. All right, the court now calls 1511-5754. This is Automotive Credit Corporation versus Jerome Pledger and Jerome Pledger Jr. That's Pledger. The matter is before the court on the filing of objections to a writ of garnishment. That garnishment was issued because a judgment was issued in this matter in 2013, struck in 2015. For $13,268.91. That judgment was renewed December the 11th of 2024 for the same amount. All right. Do I have Automotive Credit Corporation, please? Just one moment, sir. All right, appearance for Automotive Credit Corporation. Counsel, what matter are you here on?
Warren Manor Associates.
All right, that's the next matter. All right, very well. Let's see. I'm looking for counsel. Do I have Jerome Pledger, please?
Yes.
All right, good morning to you, sir. I'm seeing there's an attorney on the other side. I'm trying to look here and see what's going on. So this iPhone person, let me turn off videos for just a moment. So if your video is turned off, I'll get you back on for just a moment. All right, person who came in on the iPhone, who are you?
Attorney Rick Bruce.
All right, thank you, Mr. Russo. I had to turn off some things because we had some rumors, Zoom trying to mess some stuff up. Okay. All right. So on the record in 5754, Automotive Credit Corporation versus Pledger. Are you on that matter, sir? Your appearance, if you will, on Automotive.
Oh, I'm Attorney Richard Drusen. I am
the attorney of record for the plaintiff, my bar number 35222. Today, Judge, I am the respondent to defendant's objection to a bank garnishment.
All right, thank you, counsel. And I have Mr. Pledger on this Zoom at this time. Mr. Pledger, I looked at your objection. It says you never received any notice of a letter and money was taken out of your account. Of course, I mentioned to you that the reason for the garnishment is that outstanding judgment. Tell me what you're trying to tell me, Mr. Pledger.
Well, I mean, I know that I do owe for the car or whatever, but usually, like when you get garnished, they give you you get notified in the mail that they about to garnish you. And
No, not on the garnishment. You get the notice after the garnishment. That's the way. That's the whole point of it, to keep you from going and getting the money. So it's supposed to come by surprise.
Yeah, but
go ahead. Go ahead.
One thing on that with that account, it was me and my girlfriend's joint account, but they told me that my car was closed, my account was closed. That was her income tax money that came to the account, and they just up and took it. That's what the whole issue about. I'm not knocking me on them or whatever, but it's just when they did that, that was her income tax money that went to that account. Like, I don't even use that account or nothing. They told me my end was closed. I didn't even know my name was still on the savings part. And that's where they got it from.
Yeah, that makes you an owner of that account, unfortunately. Well, let me hear from Mr. Rose and I'll come back. How much money was taken, Mr. Pleasure? Do you know?
Like 1,700.
Right. Mr. Rose?
Well, Judge, may I please the disclosure from the bank. Apparently, the disclosure from the bank was for the sum of $1,611. Now, I can tell you, Judge, I have no information about any co-owners in the bank account. I have no information but for the two documents I've received that brought us to your docket, which is Mr. Pledger's objection, and the one-page document from the bank said we're withholding $1,611.
Wow. But, Mr. Pleasure, if that being the case, I mean, it's got your name on it, and that's money.
Yeah, that being said, that's the problem I have, Judge. So I don't have any way to dispute or.
Mr. Rosen, you're breaking up completely, and I need to hear what you're saying now. Maybe you should. Can you go out and come back in, because you're breaking up bad.
Go out and come back. Yeah.
Okay.
I'm going now. I'll be right back.
Okay. Just one moment, Mr. Pledger. I want to hear what he had to say.
There we go. Let's try this again. All right. Judge, can you hear me?
Yes, sir.
Okay, great. So the only information I have in listening to Mr. Pelger's argument on the record is just his one-page objection and the one-page disclosure I received from the bank. And again, based on the record, if it's a joint account, he's got equal access as to the account money as well as his girlfriend. So therefore, I ask you to deny the objection today. My name's still on there.
Yeah, Mr. Pledger, given that you're joint on this account, that your name is still on it, there's nothing here to establish any other ownership on the account. When your name is attached to something, you have a judgment that makes those items subject to garnishment, and therein lies the problem here. Go ahead. I'm listening to you, Mr. Pledger.
You said, and they said there's no other name on the account?
Well, the notification, I believe the attorney said that he received it, did not display some other person's name, but it definitely has your name on it. That's the problem. That's the biggest part of the problem, is that your name and your identification is attached to that, and then you have a judgment. So that's why the bank seize the money because that judgment says, if you have some money with Mr. Blazer's name on it, then you got to turn it over. And that's what they did. And I don't see an objection to that. So, you know, looks like you're gonna have to pay your girlfriend back, if that's her money, because your name is all over. All right, so I would have to find that there's not a valid objection here, Mr. Clegg. And the funds will then be released to the plaintiff to be applied towards the judgment balance. I do wish you well, sir. Thank you. Good day.
Thank you, Russ.
All right, we are on the record in 17-1-1-8894. That's Warren Associates LLC versus Tanaya Green. In just one moment, counsel, on that matter, let me step back for a moment to Arrow Financial versus David Williams. The suffix in that matter is 5696. Welcome back, Mr. Johnson. Welcome back, Mr. Williams. Mr. Johnson, updating on things, sir.
Thank you, Your Honor. Mr. Williams and his wife graciously were in the breakout room. They gave me a proposal regarding the interest. I don't have approval for that at this time. They did give me an email address where I can communicate with them further. But yeah, we really have nothing on reducing the balance at this point.
All right. So I'm going to sign the order to allow for the garnishment to be reduced to up to $50 per pay. And that will reduce that amount. And sir, Mr. Johnson, they're going to hear back from you when regarding this matter?
I'm putting in their proposal to my client today, and as soon as I hear from my client regarding that, I will reach out to this email address and let them know, and then they can do the next steps, whatever those are. Hopefully they accept their proposal and we can just move on with this.
All right. So what I'll do is I will set a review date just so I can take another look at that issue, and I'm going to go ahead and set that up for April the 17th, for 17/25 at 9:45. That's when it will come back in front of me. Let me take a look at it. Hopefully you guys get it worked out, and I'll take a look at it at that time. And in the meantime, Mr. Williams, you'll get an order from me limiting the amount of the garnishment to $50 per pay period. And we'll send that to your payroll department. But when you get it, you make sure that you take it to them so that they can reduce it to the up to $50 per pay rather than the amount that is being taken down.
Yes, sir. How would I receive that?
I'm going to send it to you in mail at the address in Southville on Lindenwood Street.
I stay in Florida.
We sent in a correction of address.
I sent in a correction of address.
Yeah, the only address I have is the Southville address, and then I do have the address to the Auburndale, Florida address regarding
Auburndale.
That's your job's address.
Sir?
Yeah, I have your job address. Let me see, just one moment. Just a second. One second. Okay. I do have something on I believe it's 6 Lake Ida Street.
No, sir.
No, sir.
890 Winter Haven.
Excuse me?
I'm trying to figure out, well, wait a minute, I see a bunch of stuff. Okay, what about 35th Street?
Yes, sir.
That's
Okay,
correct.
that's in Winter Haven, correct?
Correct. Yes, sir.
Okay, I'll make sure that it gets sent to that address, sir.
Yes, sir.
All right, and then you have, you're gonna get something with the next date on this, just to try to deal with the interest of it. Not a whole lot I can do, but I wanna hear what the parties are and see if there's anything further that can be done. So I'll review it on the 17th of April.
Thank you, sir.
Receive an order from me in the next couple of days. All right, good day to you. Thank you, Council.
Thank you, sir.
Thank you, Your Honor. Thank you, Mr. Williams, Mr. and Mrs. Williams.
Thank
Yes, sir.
you.
Thank you, sir.
Good day to both. All right, we're back on the record regarding the suffix 8894. That is the filing of objections to a writ of garnishment. There's also with that the filing of a petition for installment payments in this matter. Do I have Ms. Green on this Zoom? I believe I have Ms. Green. Good morning to you, Ms. Green.
Good morning. Yes, I'm here.
So the judgment was entered for $1,517 back in 2017. And you indicated that you want to pay $50 a month on that. Is that basically what you're objecting about as well, ma'am? Yes.
Well, yes, because this is my first time hearing about it. So that was all that I was told that I could object on.
Okay.
When I came down to the court, the 36th district.
But it sounds like to me, well, are you disputing the judgment itself?
I don't even know. I just know this is my first time hearing about it through my job, through my employment.
Okay.
So I don't even know anything about, I was never served. I didn't even owe anything. I believe I owed $500 when I moved because I was month to month. So how is it that it's even this high, or stating that I was served in 2017 when I wasn't?
Yeah, well, I have to go with that service from back then. Let's see what else happened. Then there were attempts to garnish your income taxes in 2018, in 2024, etc. Counsel, let me hear from you regarding this matter.
Yeah, I have no objection to her installment payment motion. I was just, I was appearing today because she didn't state a reason as to why she's objecting to the garnishment itself. So I would just ask that whatever has been withheld be released to me. And then moving forward, like I said, I'm okay with an installment payment order as opposed to garnishing her wages.
All right, ma'am. So there really was not a stated objection. And I don't think that, unfortunately, at this point, that you have a valid objection that you could raise at this time. So I'd have to find the objection invalid, and any funds withheld will be released to the plaintiff to be applied towards the judgment. Then I will suspend the garnishment. So we're gonna suspend that. I'm writing while talking, so just one moment.
Okay.
So I'm suspending the withholding under the garnishment, and then I'm gonna set you up a partial payment order, and you'll be able to do it voluntarily at $50 per month. I'm gonna make that payment due on the 11th of April, so 4/11/25 is when you want to make the $50 payment each month. On or before the 11th of the month is when you will make the $50 payment.
Is there any, I'm sorry.
Go ahead, I'm listening to you.
Is there any way that it could be pushed towards the end of April? Because they notified me of the writ of garnishment, my job did, on, I believe, the 3rd. and I was fired on the 5th. So I no longer even have a job now. So is there any way that it could be pushed towards the end of April? Then maybe I could have enough time to come up with the first payment? Because I just filed for unemployment and I believe I can't even certify until the first week of April.
Council?
I'm okay with that.
All right, so we'll set it over, ma'am, for the 25th of April, 4/25. 25,
Okay.
I'm sorry that you terminated. That's not. I wish you well going forward, but I will set it over for the end of the month. And,
Okay.
all right, so all the best to you, ma'am.
Thank you.
Right, and good day to you. Thank you,
Thank you.
Council.
Thank you, Judge.